Good afternoon, everyone. I'm going to give it one more minute before we get started to let people join. All right, in the interest of time, I'm going to go ahead and get started. So good afternoon. Welcome to the Environmental Law Institute's webinar on environmental justice litigation. I'm Madison Calhoun, Senior Manager of Educational Programs here at ELI. We are so excited about this series. We are partnering with Latham & Watkins to create a three-part series about environmental justice litigation. The series will take a deep look at the evolution of environmental justice within the legal system of the United States, as well as the creative ways attorneys have used environmental and civil rights laws to advocate on behalf of environmental justice communities. Today's event is the first part of that series. It will focus on the foundational principles and elements of environmental justice. Our moderator, Ariel, will lead the panelists in a roundtable discussion explaining the racial justice origins of the field and the timeline of key events that have developed the practice of environmental justice. The second part of the series will take place on May 18th, and the final part will take place on June 8th. I'll link to the event pages in the chat if you'd like to register for those as well. We would love to have you. I want to take a moment to thank Ariel for moderating and our panelists for taking the time to prepare for this important event. Also, thank you to everyone in attendance for joining us today. We do welcome questions, so please ask them as soon as you think of them through Zoom's questions box. We encourage you to submit them throughout the webinar, and we will try to address them as we go along. So now I would like to turn things over to our wonderful moderator, Ariel. Ariel King is the Environmental Justice Staff Attorney here at ELI. Ariel has a background in environmental racism analysis, political ecology, critical race theory, sustainability, civil rights law, and integrating equity and environmental justice considerations into climate action plans. She's passionate about making environmental education inclusive and accessible to all. She holds a JD and a master's in environmental law and policy from Vermont Law School and a BA from Bard College at Simon's Rock. Ariel, I'll turn things over to you. Thank you so much, everyone.
All right, thank you, Madison. Good afternoon, everyone, and thank you for joining us for part one of the three-part series on environmental justice litigation in partnership with Latham & Watkins. As the EJ staff attorney here at ELI, I am proud to introduce these three dynamic practitioners who will share some of the foundational principles and elements of environmental justice lawyering. Throughout this discussion, as has already been mentioned, I ask that those watching please send panelists questions through the Q&A function here on Zoom. I will try to get through as many questions as time will allow. And without further ado, I want to introduce our panelists for today's discussion. First is Nikki Buffa. As a partner at Latham & Watkins, Nikki provides environmental counseling in all areas of environmental law with a particular focus on the siting of major infrastructure projects, the energy transition and renewable energy, stakeholder engagement, and crisis management. She spent 13 years in the federal government in career and political appointed positions, 8 years in the Obama administration at both the White House and the Department of the Interior, where she served as the Deputy Chief of Staff to Secretary Sally Jewell. And in 2020 to 2021, Ms. Buffa was on the Biden-Harris presidential transition team as the White House Council on Environmental Quality Transition Team Lead. She currently serves on the board of the Irvine Ridge Conservancy, the National Parks Conservation Association, and the advisory board of the University of California at Berkeley's Institute for Parks, People, and Biodiversity. Next is Amy Laura Kahn, who is a visiting professor and director of the Environmental Justice Clinic. Through movement lawyering practice and scholarship, Amy Laura collaborates with organizers and communities to confront the cumulative effects of racial segregation, neighborhood disinvestment, and environmental and climate risk, and support self-determination. Prior to joining Vermont Law School, Amy Laura served as senior attorney and interim director of the Healthy Communities and Environmental Justice Program at the Conservation Law Foundation, launching CLF's community lawyering program. Amy Laura joined CLF from the Public Interest Law Center in Philadelphia, where she was a Skadden Fellow and director of the Green Justice Legal Initiative, the nation's first urban agricultural law clinic. For 5 years, Amy Laura served as legal counsel for residents in the frontline floodplain community of Eastwick in addressing legacy injustice of the country's largest urban renewal project. She is a longtime community organizer and co-founder of the Lower Manhattan's Blue Stockings bookstore. And she has a BA summa cum laude from Hunter College and a JD magna cum laude from the University of Pennsylvania Law School. Last but certainly not least is Daria E. Neal, who is the Deputy Chief of the U.S. State Department of Justice, Civil Rights Division, Federal Coordination and Compliance Section. Ms. Neal oversees teams of attorneys who work with the federal agencies to ensure consistent and effective enforcement of civil rights statutes and executive orders that prohibit discrimination in federally conducted and assisted programs and activities, including Title VI of the Civil Rights Act of 1964. Ms. Neal has represented the Civil Rights Division on the White House Environmental Justice Interagency Council and leads its Title VI committee to improve interagency coordination of civil rights enforcement in matters related to discriminatory environmental and health burdens of pollution. Prior to joining the Department of Justice, Ms. Neal was a senior counsel for environmental justice projects at the Lawyers Committee for Civil Rights Under Law. Ms. Neal is currently an adjunct professor at Howard University School of Law and has served as an adjunct at NYU School of Law, teaching courses on environmental justice and civil rights. Ms. Neal is a proud graduate of Hampton University and received her law degree from the University of California, Los Angeles School of Law. So let's get into it. Let's start this conversation. First, the concept of environmental justice has very deep roots in the United States. Amy Laura, could you perhaps start us off with discussing some of the key historical events that make up the start of the environmental justice movement?
Absolutely. Thank you so much, Ariel. And it's really great to be here with Nikki and Daria. I think it's important to note that there's not one moment that started the movement, that people of color, indigenous communities and tribal nations and low-income communities have been fighting disproportionate impacts of environmental and now climate burdens for generations, but that there are also some key milestones, and that it's crucial to ground our work in the history and principles of the environmental justice movement. We often and I think increasingly point to a very early moment in the environmental justice movement as the Memphis sanitation strike, when 1,300 Black men from the Memphis Department of Public Works went on strike in response to a long pattern of neglect and abuse of its Black employees, but also the death of two garbage collectors, Echo Cole and Robert Walker, who were crushed to death by a malfunctioning truck. And that strike really shows us the link between environmental justice, civil rights movement, labor, and economic justice struggles, and one that the Reverend Dr. Martin Luther King Jr. spoke to in speaking to the workers the night before his assassination in Memphis. And so that is a key early moment, and one that very much brings together a lot of the struggles that we see and the themes that we see over time. Another key early moment is the Bean versus Southwestern Waste Management Corporation case that arose in Houston, Texas, through which residents of Harris County contested the Texas Department of Health's grant of a permit for a solid waste facility in a predominantly Black community. And that was the first instance of an environmental justice issue being brought to the courts through a civil rights claim. The district court in Bean ultimately found that the placement of the dump would irreparably harm the community, that the landfill would affect the entire nature of the community, its land values, its tax base, its aesthetics, its health and safety, and the operation of a high school located only 1,700 feet from the site. But the community was unable to get redress. They were unable to establish intentional discrimination and were never granted relief, and the plant was built. And this has really is a theme throughout the history in terms of environmental justice struggles. At the same time, so much came out of that moment. The attorney for Margaret Bean and other Houston residents was Linda McKeever Bullard. Her husband, Dr. Robert Bullard, was drawn into the case as an expert witness and ended up kind of doing a deep dive into these issues, and really is known as the grandfather of environmental justice, did a study called Solid Waste Sites and the Black Houston Community as a way of suddenly realizing, of really surfacing the fact that this is a systemic issue. And that the documentation by Dr. Bullard over time has really transformed how we were able to think about the fact that this is an issue of systemic racism. Another key moment, 1982, arose in Warren County, North Carolina, when after 3 months of illegal dumping of PCBs over a long stretch of road, the state of North Carolina decided that they were going to remediate that site by piling 40,000 cubic yards of PCBs in a majority Black community in Warren County, resulting in a national attention to nonviolent direct action with over 500 protesters arrested, and really bringing national attention to this issue. And in that moment, there was a sort of coining of the phrase environmental racism as a known phenomenon. Coming out of that, in 1983, the US General Accounting Office did a study kind of prompted by the participation of a District of Columbia delegate in that protest in North Carolina. And that study found that 3 out of 4 offsite hazardous waste landfills in the region in the Southeast were located in predominantly Black communities. That study led to another study, the 1987 Toxic Waste and Race Study in the US, which has really been foundational, a national study pointing to the fact that communities with greater communities of color were more likely to be the sites of commercial hazardous waste facilities. 20 years later, that data remains true. And then out of this, a whole set of movement building. So you have the founding of all sorts of organizations around the country. West Harlem Environmental Action in 1988, WE ACT, the Indigenous Environmental Network in 1990, Southwest Network for Environmental and Economic Justice in 1990, Deep South Center for Environmental Justice, founded at Xavier University in 1992. And many of these organizations then coming together in 1990 to write a letter that we call the Southwest Organizing Project Letter to Group of 10, where EJ organizations, environmental justice organizations, came together to actually be in dialogue with the environmental movement to say, hey, environmental movement, folks, you are not being responsive to us. And in fact, the practices that you are engaging in are in fact harming our communities. A really important moment in many ways because those patterns continue, and it's a document that I return to very consistently because it really names some of the issues that we see today. And then finally, I will end by noting in 1991, the first National People of Color Summit in DC, at which the 17 principles of environmental justice were drafted, and then followed very closely in 96 by the Jemez Principles for Democratic Organizing. And I will hand the mic back to Ariel with that and put the links to the principles, these 2 sets of principles in the chat, because these, like the letter to the Group of 10, are principles that we return to kind of day after day in this work.
Thank you. Thank you so much for laying the foundation for us, Amy Laura. And so the next question is, what and where and how does environmental justice fit into the Constitution? And yes, would someone like to tackle that question?
I'm handing that one over to the law professors.
Does anyone want, Daria, do you want to take that?
Sure. So one thing I just want to make sure is clear, that I'm here in my personal capacity. I appreciate Ariel, you sharing my bio, but just for the record, I'm here as an individual, and I guess I can also say as an adjunct professor at Howard. I mean, frankly, the Constitution allows for Congress to enact laws for the public welfare. And so there are a range of statutes, as you know, that have been enacted to protect the environment, as well as a range of laws enacted to advance civil rights and ensure equal protection under the law. And really, environmental justice is a marriage of social justice movement, civil rights movement, as Amy Laura mentioned earlier, the labor movement, as well as the environmental movement. And I think, frankly, early environmental activism did not account for impacts on marginalized communities, African-American communities, indigenous communities, and those communities recognize the importance of ensuring protection from environmental pollution, as well as protecting human health. And as Amy Laura mentioned, all of the activism that had occurred. And so as a result, you see statutes being utilized in ways to really advance environmental protection and protection of human health in communities of color, in low-income communities, in ways that may have not originally been envisioned when they were enacted, as well as civil rights statutes, frankly. And so to that extent that the Constitution affords the ability to, one, to ensure equal protection under the law, but two, for Congress to enact legislation that allows for protecting the public welfare, environmental justice really falls within that spirit. And then further, the executive branch being able to advance policies that ensure for just treatment of all individuals, and to, frankly, address disparities where the law allows and where its authority is allowed.
Thank you. And so at some point, dating back to at least the early 90s, Amy Laura, you alluded to this a bit, the US government jumped into the conversation related to environmental justice and started taking action. And I know that Nikki has had some experience in the EPA and in the government in the 90s. So first, what did EJ look like from your perspective then? And would you mind taking a moment to talk about some of the potential things that were, sought to be addressed during that time within EPA?
Absolutely. So I joined the EPA in Region 9 in San Francisco in 1998. And that was several years after the Clinton administration had signed their executive order on environmental justice, urging the federal departments and agencies to try to tackle this problem. And one of the things that I saw right away, just coming in as a junior, right out of college staffer, was how difficult it was for EPA itself to figure out just how to do that. They didn't necessarily have the tools to identify where the environmental justice areas were. And then they didn't know that they had the authority to actually do anything to then help those areas. That's one person's perspective who's no longer at the EPA. So, from my perspective, I had been spending a lot of time working on GIS maps while I was in college. And I developed a series of maps, and because I saw my supervisors struggling with, like, where are these places? And I made these maps of our region that, overlaid all this census data on a bunch of different criteria, right? So your ethnicity, your income, and then I put little dots where all the pollutant sources were according to our EPA databases. And I showed it to my supervisor at the time. And again, I think I was like a GS7, right? Like at the very bottom. And he says, this is great because we haven't figured out how to do this yet. Let's go walk you around to all the different permitting offices in the building, and you can show them your maps. So I remember getting to the RCRA permitting office and sitting down, and this little baby employee, again, I can't stress that enough. And I'm handing these maps over and I'm saying, look, we have this executive order. People say they don't know where these areas are. Like, you can see these clusters of facilities. You can see all this societal information on top of those clusters. And I remember a lawyer looked at me and said, so you're telling me that if I have a permit application that comes in for one of these places, I have to deny it because of your map? That would be arbitrary and capricious. And I had never heard those words before. I didn't know what those words meant. And that's where I was like, I think I need to go to law school, because that person seems to know something I don't understand about how the permitting process works. And that was back in, again, I think that must have been 1999 at that point. And it was people were really, really struggling. I think that the agency and the administration has obviously gone leaps and bounds past that now, right? But there are still the same questions people are still asking themselves. what exactly is an environmental justice area. There are tools being developed to identify them that look a lot like those maps, but are way better. And so I think that I love this conversation. I want to continue this conversation, but from my perspective, that's what it looked like then. Happy to talk a little bit later about kind of how I'm seeing things today.
Thank you. And would either of the other panelists be interested in sharing some of the kind of growth or evolution of tools that EPA and other agencies have used to advance environmental justice that you've seen since the 90s until today?
So I'll just jump in. So I'll say even recently, EPA has developed a toolkit for their civil rights program to not just address environmental justice broadly, but in using Title VI of the Civil Rights Act to advance environmental justice. And so back in 2017, they developed this toolkit to really provide technical assistance to their recipients of EPA funding and to ensure compliance with civil rights statutes. They've also developed a strategic plan for how they're going to implement and effectuate Title VI in their program, and a case resolution manual, which really I think is an important resource for the regulated community to understand how EPA specifically is going to look at civil rights claims as it relates to environmental justice issues. One thing you asked about tools currently, and Nikki mentioned various screening tools. Just this year, the White House issued or published really a beta version of a economic and climate justice screening tool. And this really actually builds off of the EPA's EJ screen, which some of you might be familiar with. And I think probably Nikki is more of an expert on this than I am. But really it's an effort to identify where communities are located in relation to polluting facilities. And the new tool really is, I think, an effort to really dig in deeper into the data to help state agencies and frankly advocates to identify where there may be cumulative impacts from polluting facilities in order to address systemic burdens that communities have faced over the years.
And I just put a link in the chat to the new tool so folks can see it.
Thank you. And so maybe Amy Laura, would you be able to speak to some of the gaps within environmental law that create barriers to redress for environmental justice communities? You talked briefly about that, especially starting with the Bean case. But like, what does that look like today, and how are attorneys working to kind of work around that and to still create redress for environmental justice communities?
Thanks so much, Ariel. And I can I'll start to answer that, and also in the process, I think answer Blakely's question around state action a little bit. So, very just broadly, I'm going to talk a little bit about some of the sort of bigger barriers, and so there are some real gaps in our environmental legal regime that in the way that it is constructed, that allow for really the perpetuation of kind of the disproportionate burden and burdens of environmental racism. And some of that, one example of that is really in the way that our environmental statutes are focusing on environmental as opposed to health-based standards. And so there's a gap there if we look at the Clean Air Act, for example, in the NAAQS, or if we look at the Safe Drinking Water Act, or even the Federal Insecticide, Fungicide, and Rodenticide Act, as it relates to the impacts on farm workers. There are, we are are regulating levels of pollutants and a kind of the exposure to pollutants and point source pollution kind of on an individual pollutant basis in a way that sets these environmental standards, but they don't necessarily address the impact of those standards on human health. And one of those gaps has to do with this concept of cumulative impacts and the fact that many, in fact, most of our environmental statutes don't address the fact that an individual person, an individual body, or an individual community is experiencing many impacts of individual point source pollutants together. I as an individual I'm not experiencing like volatile organic compounds separately from how I am somehow experiencing PCBs or lead. All of those things kind of come together and create cumulative impacts, a cumulative set of risks that are felt as cumulative impacts. But our statutes, beyond, with the exception of, I guess very recently, again, the National Environmental Policy Act, don't require that evaluation of cumulative impacts. And so that's one of the major gaps. A second gap really relates to one of the things that Daria talked about, which is the application of Title VI of the Civil Rights Act of 1964. That could be a tool that could be used very effectively to address this phenomenon of disparate impact discrimination, of the disproportionate burdening of communities of color that functions as disparate impact discrimination. But one of the barriers to that redress was a case called Alexander v. Sandoval, decided by the Supreme Court in 2001, that said that individuals do not have a private right of action to seek redress from the courts based on disparate impact discrimination. So the Bean case was allowable because it was a case of intentional discrimination, even though the plaintiffs did not succeed. But if I don't have enough of it, if I don't have the evidence for that intent, I actually have to seek redress through an agency like DOJ or the EPA or Department of Transportation, and that has not, systemically there have been real barriers to doing that specifically with EPA. There have been a number of hurdles. So those are sort of two major issues in terms of how that's playing out at the state level. And in particular with permitting, because that was one of the questions. States are increasingly passing statutes, seeing the issuance of executive orders, and then also kind of in some places policies to start to address things on a state-by-state level. We were seeing, for example, very recently, Massachusetts and New Jersey pass legislation that require evaluation of cumulative impacts. And right now we're watching these regulatory processes happen to understand, well, how does that actually work? New Jersey has provided us with what we think is the gold standard, because it will require the denial of certain permits if there is a cumulative impacts, if there is a cumulative impact on an environmental justice community. But again, we are watching very closely the regulatory process, both in Massachusetts and in New Jersey, to see, okay, like, how does this play out in practice? Vermont is considering something similar. The city of Philadelphia is also considering an ordinance that would do something on a local level. So, and then in terms of filling that civil rights gap, Massachusetts is also considering creating a private right of action at a state level for disparate impact discrimination. Illinois and California already have those in place.
Thank you so much. And thank you for just enlightening us on some of the examples that we're seeing on the state level. I think it's really important to share the ways that state and federal government are working towards advancing these initiatives. And so along with that, let's turn to Justice 40, which is a new practice and kind of framework that is coming out of the Biden administration. Nikki, we'd love to hear a little bit more about the initiative, specifically maybe the definition of disadvantaged communities, and maybe if possible, tying that into one of the questions that we've been asked by one of our viewers who asked about omitting race as a factor in the climate and economic justice screening tool. If you have any maybe comparisons for, omitting or adding race as a factor, or what went into the, criteria for defining disadvantaged communities for Justice 40.
Sure. There's a lot to unpack there. So let's start with the thought behind Justice 40, right? So when Joe Biden was campaigning for president, he made environmental justice actually a key component of his environmental and climate change platform. He talked about it a lot, right? More than he talked about some of the other issues that traditional environmental groups used to ask the administration to talk about. He really saw, I think, the importance of connecting the environment with social justice issues, and EJ was like the perfect place to do that. So on the campaign, on the transition, in the early days of the administration, there were moments where you saw the administration and again, Joe Biden on the campaign, talk about environmental justice. So Justice 40, I think, was kind of the catch-all for his environmental justice platform. On the transition, there was a lot of time spent on thinking about Justice 40, thinking about environmental justice, thinking about the first 100 days and what could be done in the first 100 days of this administration to progress the fight against the fight for environmental justice. So one of the things that everybody saw was, I think it was like day 8, the Biden administration, Joe Biden signed an executive order. It was something like tackling the climate crisis. And in that executive order, he established the National Climate Task Force. And part of that task force, which was a group of cabinet members and the heads of agencies, they not only had to prioritize action on climate change, but they also had to address the disproportionate impact that climate change has on disadvantaged communities. And in that executive order, they made the commitment that 40% of the overall benefits of federal investments would go to disadvantaged communities. So that's where the 40 comes in, because again, 40% of the overall benefits of federal investments were going to go to disadvantaged communities, are to go to disadvantaged communities. And I think there is still today a struggle around how do you define what is an overall benefit? What are the overall benefits of federal investments? Like, what is a benefit of an investment? What is an investment? And then what are the disadvantaged communities? So there's a lot tied into that commitment. And I think this administration is having a hard time defining those components and then implementing them. But frankly, like, God bless them for trying, as far as I'm concerned. And that's that tool that Daria talked about, I think, is an important step in delivering on that promise, right? So what that tool can do for those of you who might have, been at your computer and able to play around, you'll see if you put in your zip code, you actually, get an answer. It'll say, is this census tract disadvantaged? Yes or no. And it gives you a yes or no, which to me, like, we've never seen that before, right? So the California has a screening tool called the Cal Enviro Screen, which I can also put in the chat later. They've been playing around with Cal Enviro Screen for a number of years and getting it to a point where a lot of folks, use it on a daily basis, especially those in the environmental justice community, those who are fighting for environmental justice, but also some of my clients are trying to build projects to understand, like, what's going on in this community. What factors do we need to address if we want to get our projects done? And so with the with the scorecard Enviro Screen, you actually get a percentile, right? That tells you, this census tract is in the 99th percentile of all disadvantaged communities within California. And it's a relative scale. It's relative to the other census tracts in California. This tool that the Biden administration put out is actually like a yes or no answer. And so you'll see when you play around with it that there are all these different factors in there. They range from accessibility to transit, to the workforce development, like how many people are unemployed, to looking at different pollutant sources that people might be exposed to that live in the area. And now the administration said, okay, this is a beta. This tool that we put out, it's a beta version. So everybody go online, take a look, submit your feedback, let us know what you think. Unfortunately, for all of you who are like dying to write a comment letter right now, the public comment period ended yesterday, but I think there's still ways always to get in and kind of get in people's ears. But there were a number of people who were very activated upon seeing this tool, right? That think there are other factors that need to be considered. There are some factors that should be considered less. A bunch of senators wrote a letter to the administration kind of outlining their views, and they were quick to say, by the way, this isn't just us. We talked to a bunch of EJ community groups too when we wrote you this letter. So if you're interested, you can look at it. It's from Cardin and Senator Feinstein and Cory Booker and Padilla were all in this letter, and they outlined the 5 or 6 other things that need to be in that screening tool. And I think right now, if I know this administration, they are looking at that letter and the hundreds of other letters they got, and they're trying to perfect this tool. And one of the other things that the tool does, if you go in and play with it, when you see your answer, yes or no disadvantage, you can submit feedback. You could write a little comment that's like, this is wrong, and here's why I think this is wrong. And it's a way of trying to engage the public. So I think that, again, this administration set a laudable goal. They are really trying. And this screening tool, I think, was kind of a really big first step. There's another thing that the executive order asked for, which was a scorecard. And it was for the administration to be judged on a scorecard. And scorecards have been used for administrations time and time again. The Trump administration used one. We used them in the Obama administration when we were looking at sustainability and just how sustainable certain agencies were. We did these sustainability scorecards. So now there's going to be this environmental justice scorecard. And it was supposed to be produced this February 22nd this year. I'm sorry, February 22. So this year, a few months ago, it didn't make its way out yet. And instead, what we heard was at a WEJAC meeting, the White House Environmental Justice Advisory Council meeting, the chair of the Council of Environmental Quality, Brenda Mallory, got up and said, these scorecards are really important. We need to get the scorecard done. We get it, but we need your help. We need your thoughts on what should be included in the scorecard, because I think they're reeling from the tool, right? And all the stuff they did in the tool and all the responses they got on the tool. So they're looking for feedback on those scorecards now. And we should be seeing one this year, is what I heard Chair Mallory say in her remarks. So that's another next step I think we should all look out for.
Thank you. And Nikki, in private practice, in what you've seen so far, how do you think, since there hasn't really been like full action yet, what do you predict some of the challenges or potential ways that clients might be able to utilize or benefit from Justice 40 in your practice and what you do?
Well, there are a variety of different things. So what I mainly try to do, and a lot of us at Latham do, is help big projects get built, right? And some of these projects are projects that actually would help and benefit the climate and prevent climate change and transition us into a cleaner energy economy, just like we hear the Biden administration say, and out here in California, the Governor Newsom administration say all the time. When you build those big projects, even if they're for the good of the world, they can still create issues for environmental justice communities. And that is something that our clients are typically very sensitive to and want to figure out ways to address, whether it's moving into a different community, moving outside of a big city, or without sharing fence lines with community members, working together at the very beginning to develop stakeholder groups and meetings. It's all about transparency. We spend a lot of time at Latham with our clients and with our consultants to figure out ways to engage the community as we're trying to develop projects. And these tools I was just mentioning are good ways to identify particular areas, to get at the issues these areas are facing. And then you start entering into agreements with the communities. You provide them the things that they're missing, and you try to give them the benefits of what the project's going to bring. So if you're building an energy, some very clean energy technology, and you're sharing a fence line with a community, you're going to benefit maybe the whole state, right? Let's say you're manufacturing biodiesel, you're going to reduce the really nasty stuff that comes out of diesel emissions, you're switching everybody to green hydrogen, whatever it is you're doing. When you're still building, for instance, that diesel facility, you still might have impacts. So how do you make sure that the people in that community are actually those impacts are going to be mitigated? we spend a lot of time talking about that, or frankly, just finding a new place to site a facility. But again, I think our experience in working with those folks, working with those community members, and then these tools the administration are providing are really the steps we need to kind of help make sure we're lessening our impact or just eliminating it.
Absolutely. So taking a step back, outside of the Civil Rights Act of 1964, what are some other laws or regulations that practitioners use to advance environmental justice, kind of outside of the traditional environmental legal context?
So I'll jump in and Amy Laura can add. We've mentioned Title VI of the Civil Rights Act, but really haven't, I think, explained what that covers. So Title VI prohibits discrimination on the basis of race, color, and national origin in programs and activities that receive federal financial assistance. And so what does that mean? It means most federal agencies put out money to state and local governments, state and local governmental agencies, educational institutions, and those institutions all need to comply with Title VI. And so the federal agencies also have the responsibility for ensuring compliance with 6. As Amy Laura mentioned earlier, the Supreme Court case Alexander v. Sandoval held that, at least with regards to Title VI, the statute itself doesn't allow for individuals to bring a cause of action to enforce the disparate impact regulations of the statute, which prohibit discriminatory impacts in programs and activities that receive federal funding. And so the agencies themselves are responsible for ensuring compliance. EPA has gotten a lot of attention, rightfully so, over the last 20, 25 years, probably longer than that now that it's 2022, for ineffectiveness or effectiveness, depending on your perspective on the enforcement of Title VI. In fact, in 2003, the U.S. Commission on Civil Rights had issued a report called Not in My Backyard that looked at all of the federal agencies' efforts to implement the 1994 EJ executive order and using Title VI as a tool to advance environmental justice. And it focused heavily on EPA's backlog in conducting their investigations. And back in, I think it was 2016, the commission did another report that was focused primarily on EPA's civil rights enforcement program. But that being said, other agencies have responsibilities to enforce Title VI, and they have recipients that engage in activities that impact the environment and public health. HUD, for example, has Title VI enforcement authority, but also authority under the Fair Housing Act, and therefore can use those two statutes to address adverse impacts as it relates to housing, terms and conditions of housing, as well as activities that recipients of HUD funds engage in. We often see complaints that relate to the use of community development block grants and how those funds may, in fact, exacerbate disparities between communities of color and white communities in various areas. But I also would highlight the Department of Health and Human Services. Part of environmental justice is not just protecting communities from environmental threats, but also ensuring that we're protected from adverse human health impacts from polluting facilities or polluting activities. And so HHS has responsibilities related to advancing public health, and environmental justice intersects obviously with that, and they have Title VI enforcement responsibilities. And I can say just this past year, in 2021, in November, the Department of Justice, as well as HHS, using their authorities under Title VI, opened an investigation into the Alabama Department of Public Health related to the on-site wastewater treatment programs communities in Lowndes County were experiencing the inability to manage wastewater on their property, and the allegation is that the State Department of Public Health, as well as the County Department of Public Health, had engaged in discrimination that violated Title VI. So I raise all of that, one, to not just focus on Title VI, because I know, Ariel, you asked about other statutes, but to really highlight the roles that multiple agencies have in advancing environmental justice using the civil rights statutes that they have at their disposal. But the Fair Housing Act also has been a tool that has been used in the past with some mixed success, I would say, really to address discrimination or discriminatory access to municipal services like water and sewer, for example, and may be a tool in that space that may be in some cases more effective and more accessible, I think, to attorneys for enforcement efforts.
Ariel, I'm happy to jump in. And I did
Please.
put into the chat the press release on the DOJ investigation in Lowndes County, which was a really, I think many of us were very pleased about. There was also a question about in the chat around Fair Housing Act enforcement by HUD around polluting facilities near public housing. I would say there's not a particular case that comes to mind that I can speak of, but I would just say stay tuned, because I do think that there are investigations in process, and I think we'll see more coming down the pike. Another place, and if you mentioned this, Daria, apologize for duplication, but I wasn't sure I don't think I heard Department of Transportation, and that is a place where we have DOT has really been a model, even over time, and I think across administrations, in being very consistent around Title VI compliance and enforcement. And one of the ways that they have done this is to be very robust in their guidance to funding recipients, but also be willing to investigate and make findings of discrimination, and sometimes actually withhold and delay funding in order to ensure that funding recipients get up into compliance. And that is a really necessary tool in the toolbox. It's used very rarely, but it really needs to be done. And it speaks to, and it responds very directly to what we know is a history of environmental racism in the siting of transportation projects that split Black communities, as one unfortunately very common example. And so we've seen, actually, I think DOT under Secretary Buttigieg take some very early action, particularly in Houston, but other places with that Title VI enforcement. A couple other things I will name. One is, I think more rarely, but we have seen some cases brought under the Americans with Disabilities Act, raising, because, for example, asthma can be a disability. There was a Natural Resources Defense Council case some years back around environmental justice in public housing, and the kind of indoor air quality and the impacts on community in public housing around asthma and other respiratory disease. So the ADA is a tool in the toolbox. Nuisance claims, public and private nuisance claims, can be very effective, and were very effective in closing down some really horribly emitting facilities in the South Bronx. That was another NRDC case, actually, when I was a 2L. The other thing that I will say is just beyond in the sort of the tools that we need to build that can kind of bolster our enforcement. There's some chatting going on around kind of more robust cumulative impacts approaches. And Tammy McMullen actually made a great point, which is that we're really in process in developing the methodology for assessing both cumulative risk and cumulative impacts. Don't ask me to parse out the difference between cumulative risk and cumulative impacts. But state of Minnesota has a really great definition that I'll pop into the chat. But that methodology is really in development, and I would very much watch the Massachusetts and New Jersey regulatory processes. And Massachusetts is really doing a wonderful job in being very transparent and bringing stakeholders along in the process of learning together about how to do this, and doing it in a paced way, understanding that there is a directive under the climate roadmap bill passed last year to apply a cumulative impacts analysis across a range of permits, but they're kind of doing one permitting process at a time, with the acknowledgement that they just can't take it all on at once. And so it's going to be an iterative process in Mass. And I would just say stay tuned there. I think the other thing that Ms. McFarland brought up in the chat was that we don't have a methodology right now to address cumulative impacts of chemical and non-chemical stressors. And one of the dialogues that we're in the midst of in the city of Philadelphia, through some of my work at the law school, is how are we factoring in climate impacts? So how are we addressing the cumulative impacts, for example, of air pollution and heat, or of flooding and groundwater pollution? So like, how does that what is the methodology for that? And then to quote one of my students, like, what is the standard of overburden? At what point do we if we're going to actually say that a cumulative impacts analysis is going to affect a decision and perhaps a denial of a permit, what is too much? And we don't actually have really good answers for that. And so we're going to need to figure that out. The last thing I will say in terms of tools in the toolbox is the need for kind of robust deployment of air and water quality monitoring. And we saw a great announcement actually out of EPA in late March of this year of, I think they're calling it the pollution action? I forgot exactly what the name of it is, but there's like a whole sort of deployment of resources to create a much more robust air and water quality monitoring network across the country, and do so in a way that focuses in on the needs of environmental justice communities, and also responds to the work that EJ communities are already doing through community-based and citizen science in collecting, because communities have really shouldered the burden of having to kind of prove their own overburden over many decades. And so, but those results are not always honored by, for example, EPA or others. So there's a whole sort of deployment of resources there that will make a huge difference to be able to make a case that there's a disproportionate impact, or make a case that, there's a Clean Air Act or Clean Water Act violation. So all of those tools are necessary in, to bolster enforcement in a targeted way to address environmental justice. And all of that has to happen in a way that requires meaningful participation and community engagement in a very with integrity and accountability.
Thank you. And Amy Laura, there is a follow-up question for you, asking if there are any ways to find out how DOT or any other federal agencies are addressing cumulative impacts with respect to EJ communities in permitting and NEPA analysis. So, that can go to anyone, but Amy Laura, if you have thoughts.
So I did put a great EPA resource in the chat in terms of kind of what I think is a white paper called Cumulative Impacts Recommendations for ORD Research, which I think is kind of one of the most recent kind of compilations of kind of where, like, this is where we are in this moment on the cumulative impacts piece. I don't know of a resource coming out of DOT, but I'd be interested in if others know. And the question went away, so I'm just going to go back to it. And Emily's saying you're not seeing any of my posts in the chat. I don't know what to do about that. But in terms of the cumulative impacts in permitting and NEPA analysis, we are waiting. So one thing that I do know is that we are awaiting a series of guidances from EPA's External Civil Rights Compliance Office. And there's a whole sort of work plan that's been laid out in a really kind of detailed letter to the Office of Inspector General, and that I will can try to again put in the chat here. And one of the areas of guidance will be the sort of intersection between permitting and cumulative impacts. I think, and then in terms of NEPA, there was the phase one rulemaking did, to my knowledge, bring back cumulative impacts into the NEPA analysis coming out of the Trump rule. I think one of the things we'll be paying attention to is there, kind of more kind of robust guidance in the context of the phase two NEPA rulemaking. And then what is the coordination in terms of cumulative impacts methodology across EPA and across agencies, and then across jurisdictions? So, there are all of these different processes happening at once. How does that get reconciled? That's definitely a question that I've had. So I'm not necessarily fully answering the question. And I'm in particular wondering if other folks know about how DOT addresses cumulative impacts. So I'm curious if colleagues, you have any answers to that.
Yeah, I don't, but I know that, it's old now, but DOT has the Federal Transit Administration's Environmental Justice Circular, and that may have some information that would be responsive. It's probably 10 years old now, but also their Title VI circular does have some language around doing disparity analyses. So it's not getting to cumulative impacts, but does get to looking at impacts of major service changes on communities of color in particular. So those would be references that I would check out. And like I said, they're dated, but may provide some helpful information.
Excellent. And so I want to continue urging and recommending and asking that people add more questions to the chat. This has been such a lively and wonderful conversation so far. And I did want to acknowledge one comment that mentioned that the public comment period for the climate and economic justice screening tool has been extended to May 25th. So if you do have thoughts or ways that you believe that the tool can be just added to and expanded or evolved, you still have time to add your comments there. And so one question that we have from an audience member are, what are cases in the courts right now that have successful arguments and implications for rapidly effectuating a just transition for all? So do any of the panelists know of cases right now that they're excited about, or that they think are doing meaningful work to contribute to this just transition that we are hoping to see? And that is okay if not.
I want to be more hopeful.
No, I mean, but it's real, right?
No,
and that's important.
It is real. I mean,
Yeah.
I think the things. I have my climate policy students in my head saying, no, but tell us there's some hope. I mean, I think what we're paying attention to a whole variety of things. I mean, I think we're paying attention to climate litigation, this sort of forum question around climate litigation, and even just being able to stay in state court has been a victory in a number of cases. So I think we're gonna see, that's something that we're gonna see play out, is like, well, what happens and how do some of these state courts treat the climate litigation when they've been able to actually remain there. I think, I've been paying attention to some of these rights of nature cases. And actually, there's actually a wonderful, if there are any podcast listeners here, there's a wonderful new podcast called Damages that's doing a real deep dive into rights of nature this season, which has been very interesting. I mean, I think we're also paying attention to what the climate litigation that's happening outside of the U.S. And some victories, in Europe in particular around kind of climate obligations in different jurisdictions. So that's kind of, that's where I find my hope. But also like the persistence of the Juliana plaintiffs and how that case continues, and how that case has been able to continue in a way that, for example, over a decade ago, the Kivalina case was not. So I think that's, we are watching incremental progress.
And to end on a hopeful note, also, I think we should look at Congress too. I think we're seeing a lot of progress in Congress, and the money, especially on the budget side, the infrastructure bill, the Build Back Better, which is maybe going to come back in some form or another. There's a lot of money that folks are interested in trying to get to environmental justice communities. So hopefully that will do something as well.
And I will say, I mean, in terms of, I think that distribution of resources piece is so important. We've been, so the law clinic at BLS, along with American University, Tishman Center at the New School, University of Texas at Austin, and UC Hastings have been doing this 50-state survey of environmental justice laws and policies, also looking at the territories as well. And, trying to kind of understand like where are, what is the sort of baseline, what are the different tools the states and territories are using, and then where are the sort of emerging approaches. Cumulative impacts is certainly a sort of stronger cumulative impacts approach is certainly one of the emerging ones, but also seeing the state analogs of Justice 4D, we see, the Community Leadership and Climate Protection Act in New York is really kind of out front in terms of the distribution of resources, as well as kind of creating really good process and honestly kind of robust, some robust enforcement mechanisms. Vermont is now considering an environmental justice legislation that's been passed in the House, passed in the Senate and is being considered by the House, that now includes that sort of Justice 4D analog. And then the sort of inside baseball conversations are like, well, what is a resource? Like what needs to be redistributed? And all of those kind of details are getting worked out in right now. So I think we're really seeing the evolution of our tools at the state level, and then that very much a sort of dialogue between state and federal.
If I can just build off of what you were saying, Amy Laura, about resources going out, particularly under the infrastructure bill. A lot of the states will have a lot of discretion around how some of those funds get distributed, and I think that there's a real opportunity to address past wrongs if states and their agencies are willing to do so with the funding that comes through. I do think that it unfortunately is going to be imperative that folks in those communities really try and hold their local officials and decision makers accountable for how those funds get spent. I've heard complaints about some monies already in areas going to wealthier communities when there are clearly communities that have long been experiencing neglect and disinvestment. So as far as an area to focus on in your community, in your state, to really look at where those resources are going and try to influence and ensure that they go to those who are most in need, so that we're not continuing to perpetuate the decades of discriminatory decision making. And it can be really difficult when you have existing infrastructure, as Amy Laura mentioned, with regards to highways and roads that have divided communities intentionally in the past. There can be a real temptation to simply reinforce what already exists, and a challenge to think differently about how we live together. And so I think it's going to be imperative that those who are most effective really lift up those concerns, because those decisions will be made at the state and local level.
Yeah, and just to give an example of that, there is a terrific New York Times article about the efforts in Claiborne and New Orleans neighborhood. And if folks haven't read that, I think it's important to understand that it's issues like that, it's neighborhoods like that I think this administration is trying to address in some of their infrastructure spending. And as Daria said, it's hard because it's up to the community to advocate and to put themselves in the context of articles like this and to hold the administration accountable. But I do think there is some hope when you see organizing like that. And I'll put this in the chat too. It's a great example.
Ariel, there's a great question. There are two questions that I would love to field.
Sure.
One in, so there's just one quickly in the, well, where do I start? So Tammy Mullen asked, I think we're on the same page, Tammy, thinking about some of this very similar things, but how do you sort of, I think just to sort of sum up the question, how do you think about the sort of localized public health impacts, and then also be, while also thinking about the kind of broader national and global impacts from climate change. And I would say, there are a lot of environmental and climate justice leaders who are teaching us how to think about this, and a lot of mistakes that have been made along the way. And one of the reasons that I always bring up the Southwest Organizing Project letter to the group of 10 is because the sort of patterns of what I would say the patterns of behavior in the environmental movement that are raised in that letter in terms of a kind of failure to address through the environmental movement and thus through environmental policy, the disproportionate impacts of environmental and now climate burdens on communities of color has really played out in the climate space too. And in this kind of like, in this dynamic of, two things happening at once. One is, well, many things happening at once, but two important things happening at once. One is this, we need, the climate change fight is about reducing emissions, GHG emissions in the aggregate. That it's about policies that reduce overall GHG emissions, and that this is not about a localized issue. And two, on the second dynamic being, we don't actually have time to talk about equity. And both of those things I would like to debunk, in the sense that, GHG emissions come along with co-pollutants that disproportionately harm people of color, indigenous peoples and tribal nations and low-income communities, and that we have an opportunity to and need to come up with climate solutions that actually reduce pollution in environmental justice first and most, because those are the communities that have historically been harmed the most and are the least contributors to the climate crisis. And that we have time to factor equity, and we need to, because it's really a life or death situation if we do not. And so I think a lot of the dialogues in dialogue in California have really sort of played out over time, a kind of failure to put the equity in the center of the cap and trade program, and then over time, and then seeing the impacts of that, and seeing the sort of perpetuation of pollution hotspots, even as there are reductions in emissions in the aggregate. And so there's an ongoing policy conversation around what that looks like, and what does it look like to marginalize communities of color in the policymaking process. That dynamic has played out in I would say every major climate policy conversation in the nation. At a federal level in 2008 around the regional greenhouse gas emission, the regional greenhouse gas initiative in the Northeast, and the transportation and climate initiative very recently, which the future of that being uncertain. But one of the real failures of that has been a failure to center communities of color in that conversation. So that is a real, it's both a public health issue, but it's also a real kind of equity issue in how we make policy. And that ties to the anonymous attendee question of, are there agencies or institutions that have issued best practices for public participation involving EJ communities? There are lots of agencies and institutions that have issued best practices, EPA included, I would say DOT included, lots of places that have issued these best practices. The question is, are they getting put into place? We actually developed a memo for, it's not public, although I can see if anyone has put it anywhere that I can link to, but We developed a memo for the state of Vermont, pointing out kind of best practice plans across the country. So pointing to California, Connecticut, Massachusetts, Michigan, Minnesota, Washington state. There are a number of places that have created great plans, but the question is, how are they being implemented? And, you know, if you look, for example, at the state of Michigan, there have been phenomenal, you know, potential like planning documents that have been issued, sometimes in response to Title VI complaints. But the implementation of those has not been felt by the city residents of the city of Flint. And so there's a real sometimes discrepancy between the plan that gets put in place and what actually happens on the ground.
Thank you. We have a few more questions here in the chat and in the Q&A section. One is, have we seen states actively challenging home rule or preempting local government decision-making, which is a tool? And if such things persist, what are some problems that we can foresee in the fight for environmental justice? And how will public participation in these focused local initiatives be affected?
I can defer to others. I have one example of that I can think of that's not a home rule. It's not really a home rule case, it's a public trust case. But the case that comes to mind is Robinson Township in Commonwealth of Pennsylvania that was brought under the Pennsylvania Environmental Rights Amendment around fracking. Local laws passed to prevent fracking in local municipalities. It was a plurality decision. It was the first decision in decades to really apply the Environmental Rights Amendment, and it was a phenomenal victory. And one of the things we're kind of seeing over time is how that, you know, how is that going to shape the environmental law in Pennsylvania. And I think it's still to be determined. But that's one place where the Environmental Rights Amendment was ended up being more protective of local municipal power to protect the health of the community, healthy environment. And, you know, as not really a side note, there is a kind of a sort of emergent campaign to pass similar amendments in other states. Montana has one, Hawaii has one, Pennsylvania, and now New York, I think, is the newest to pass an environmental rights amendment. And there's a whole sort of green amendment campaign now sort of emerging. But I do think that, you know, one of the things that we've been talking about around the city Philly amendment ordinance is, you know, how does the environmental rights amendment support that? But also, are there going to be kind of home rule challenges or other preemption challenges? And what is Philly allowed to do as a quote unquote first class city in the Commonwealth versus other municipalities who have a different status?
Thank you. There's also a question regarding Chicago and the scrapyard fight. So for those who don't know what happened there recently, health officials denied a key permit to a scrap metal facility planned for a predominantly Latino community in Chicago, which is a tremendous victory. And so the question is asking about whether any of the panelists have, you know, internalized any lessons learned or thought through like what next steps might be and how this might be a model for other communities who are fighting for similar acts of environmental injustice.
So I'll jump in. I don't know if I can say that there are best practices that I would identify. And I think that the success at this point is really attributed to local advocacy and activism to oppose the relocation of that scrap metal facility. the pressure that was put on the mayor. And there were also several Title VI civil rights complaints that were filed, one with HUD, one with EPA. And both of them, my recollection is correct, still have open investigations related to the decision-making, not just by the mayor of Chicago or the city of Chicago, but also the Illinois Environmental Protection Agency. And then there'd been, as far as activism goes, I think that there were some residents who had also did a hunger strike to draw attention to it. And so I'm not going to say that those are best practices. I think that the activism and pressure on decision makers was really critical in what they've accomplished so far. I think there's still a lot to be seen as far as whether this sticks or not. But the community engagement and pressure, I think, was really, really important in shaping the outcome.
Thank you. And so I really want to close out this dynamic, incredible conversation by asking each of our panelists what sustains you as you continue to advocate for environmental justice and continue the fight to advance environmental justice in the legal space. And then with that, please feel free to add any closing remarks or things that you would like our audience to leave with in preparation for the next panel or any other part of their personal legal practice. So would anyone like to start the closing discussion with what sustains you in this movement?
I'm happy to go first. I would say it's the people that I've met. It's the folks that are actually in environmental justice communities who I've met with over the years, who I've gone into their homes and had coffee with them. I've walked the fence lines with them. Every time I'm in a conversation about environmental justice, I think about those people and I think about what they face. And I think for anybody who works in this area or anybody who might impact an environmental justice community, actually go there, actually be there with people and see what they're experiencing. It can really change your perspective on things. And I think it's very, very important. So that's what kind of gets me through when we talk about these issues.
Thank you. Amy, Laura, or Daria?
Go ahead.
Thanks, Amy, Laura. The same for me. And, what really, I think one of the overarching issues in environmental justice, one of the overarching principles, right, is that communities speak for themselves. And there's so many communities that are adversely impacted by so many different types of pollution or whether it's pollution, climate change. And the unfortunate thing is that there is still a lot of work to be done. And so, I believe that it's important that people have the right to live in a healthy environment where they go to school, where they live, where they eat, pray, as is often said. And to the extent that anything I can do to make our communities safer, healthier, that's what keeps me going in whatever kind of work that I do, because it's something it's important to me personally, and I think it's important to our country and our democracy. And I would say too that as far as maybe final notes and things to take forward, we've talked a bit about mapping and information. And one thing that I did want to highlight was the importance of data, and data collection has really been lifted up in this administration through the latest executive order on the tackling the climate crisis, to the racial equity executive order, and many of the equity plans that agencies have put out really emphasize the importance of data collection. And I think that the more information that communities have at their fingertips, the better that we can advocate for long-term change, and to also influence decisions that companies are making and local governments are making, because you have the information and the data to show what the impacts are of siting a new facility or re-permitting a facility or relocating a bridge or expanding a highway. That information is critical, and the more that's available to people, the more democratizing information, I think, is a term I've heard a lot lately. I think that we'll hopefully see better outcomes in the near term. And thank you, Ariel, for having us on the panel today.
And I can really only, I can only build on what Daria and Nikki have said. Really it does start with people and relationships on a really individual basis, and building relationships over time, and in my bio, I talk about, how I worked with the community in Eastwick for 5 years, where I was, every Wednesday night for 2 hours, often more than 2 hours, into the late night. But I didn't, I don't live in Philadelphia any longer, but I didn't leave Eastwick. I'm still in conversation. We, co-taught a class with Eastwick residents at Penn. Like, there's a whole sort of ongoing that those relationships remain and never go away, and are very personal and one-on-one, but they're also about movements and about the fact that what I do in terms of, I'm very intentionally bring a set of skills and analysis and a kind of language and translation function through my law training, but it's about how do I contribute that to a much larger movement that is really a long game, and it's a long game that is guided by those 17 environmental justice principles and the Hermes principles that center around self-determination and shifting power. And so I continue to kind of come back to those principles and how do we end my accountability to that larger movement, as well as in the context of that larger movement, the relationships I build over time. And it's really great to have this conversation with all of you. Some folks who I'm just meeting, and others who I've known for a little bit of time. And so this is a part of that relationship and those conversations.
Excellent. And with that, I truly do want to thank Daria, Amy, Laura, and Nikki for all that you do in this movement and for agreeing to be a part of our panel discussion today. And I will turn it over to Madison.
Yes, thank you so much. I don't really have anything else to add. Just want to echo Ariel's thanks to Daria, Amy, Laura, Nikki, and also to you, Ariel, for moderating. And thank you to everyone for listening in. We hope to see you all on May 18th at the next session of this. So thank you all so much and have a great day.
Thanks so much, y'all.
Are we off, or?
I think we're done. I think we're done.
Oh, there's still participants on. Okay. Take care.
I'll end the webinar in just 1 second. Thank you so much.
Oh, thanks. Bye-bye.
Thanks, y'all. Take care.
Good one.